SAN. She then also refers to the fact that she was appointed to the Western Cape as the Western Cape representative, the Khoi and the San, on the National Khoi and San Council. She goes on to lament the fact that despite that appointment, nothing has been done for her people. She says she's an advocate of the rights, page 43, of the rights of the First Nation people, and have for a long time been extremely frustrated about the manner in which their rights are being neglected by the government and by other statutory bodies. How many other groups of people in our country, my Lord, the poorest of the poor, do not fall into the same category? She says many of the First Nation peoples currently find themselves in dire circumstances. Our people are living in abject poverty. They are ravaged by unemployment. Drug addiction and crime is rife in most of the areas where they live, with many people being killed on a daily basis. That applies to many, many people in this country, justices, many. She says there are many factors that have contributed to the state of affairs. She's not blaming it all on the electoral system. She says lack of leadership. She wants to be a leader for her people, stand up in Parliament, in government, and lead from there. The loss of identity and trauma caused by the DOP system, centuries of oppression during colonialism under the apartheid regime, and since then. Over the years, our once proud people have become marginalized and abandoned. The dignity of our people has been ravaged, and there is an urgent need for restoration. Justices, the word dignity appears so often in the Constitution. This lady is begging for an opportunity to do something to restore the dignity of her people. Under the current political dispensation, the First Nation peoples have no voice or leadership whatsoever. And there is an urgent need for this to be remedied as soon as possible. She talks about women and children being raped. She says even though there are women in Parliament, none of these speak for the First Nation peoples. None, my Lord. This is an allegation that is not denied in the papers. It's not challenged. They all seem to have other political agendas and loyalties that take precedence over the needs, interests, and concerns of my people. She says a good illustration of this is the recent hotly debated land expropriation without compensation proposal by the ANC-led government, which is motivated on the basis that the land must be returned to the people from whom it was stolen. We know those utterances, my Lord, coming from the EFF and coming from the ANC as well. Historically, she says it's the Khoi and the San people that were the original stewards of all of the land in South Africa. And it is accordingly the First Nation peoples that were deprived of their possession of the land, not only by white people from Europe, but also by black people from the rest of Africa. The judge, I'll quote, took exception to that. But it's not denied on the papers, my Lord, as being true. It's true. All the historical data reflects that. Notwithstanding the historical reality, the First Nation peoples have effectively been excluded from the debate regarding land expropriation. In this regard, it is both my personal view as well as that of the royal priests that I represent that biblical values should be used in order to resolve the land issue. In this regard, the Word of God makes it clear that the land belongs to God and that we as the people are merely given stewardship over it. God has promised righteous people stewardship over the land. Lord, is this not with respect a solution to the land issue? She says, I'm absolutely convinced that these principles should govern any decision that stands to be taken in relation to the land, that if the ruling party does so solely on racial grounds, our country could soon be faced with civil war. My Lords, that is the level to which she goes. It is not denied on the papers. It is not denied on the papers that we need to address the land issue as a matter of urgency and that she has a significant contribution to make in that regard. And she says what her contribution is. It must be remembered, she said, that many farm labourers, and especially those in the Cape Province, where I come from, are descendants of the First Nation peoples. Any injudicious decision that is made regarding how agricultural land is to be redistributed will have a massive impact on them. As appears from the affidavit of Christo Pinar, hardly any of these workers enjoy any kind of collective representation at the moment, and neither is there anybody in Parliament at present that can speak on their behalf. Christo Pinar, your lordships will recall, I beg your pardon, justices will recall. You can see I'm from the old era. She says, they're not being heard. In Christo Pinar's affidavit, he says only 7% of agricultural workers are represented by unions. Who speaks on their behalf in Parliament when these critically important decisions get taken about the land issue? Issues which she says, if resolved in the wrong way, can result in civil war. She expresses those views, my Lord, as a Christian. She's telling the truth as she believes it in her heart and as she experiences it every day. She lives with those people. She hears their hearts. She knows how they feel. And she appreciates the need that she be given an opportunity urgently to be able to speak on their behalf. But as I've said, my Lord, it doesn't only relate to her. This is just an example of the people in our country that are desperately in need of an opportunity to speak in Parliament. When people are not given an opportunity to speak, we all know, as mediators, we know, as justices, you know, when people cannot speak and be heard, that is when they burn. That is when they burn. That is where our country, with respect, breaks down into shambles. And so the caution that she makes is not an unreal one. I don't know, justices, whether you looked at the clip of the home of King Louis that is part of your papers. King Louis is a king. He's a king of the Khoi nation, recognized with a staff that was given to him by Lord Caledon. Recognized, a king. He lives, my Lord, in abject poverty. Justices, if you were to go there, you will leave in tears. That is the status of the nation, the First Nation people that we are talking about. But that is not all, justices. We've all seen it on the television these last couple of weeks in the run-up to the elections of people living in houses that are falling apart, with no water, with no sanitation. We've got complete lack of accountability in our country. And things need to be remedied, justices, fast and soon. We don't have time to wait another 5 years with the current electoral system. And we know, with respect, what the current electoral system has done. You know, justices, that the cost of state capture and corruption in our country is 1.5 billion rand the last 5 years. 1.5 billion rand in monetary terms. Sorry, trillion, I beg your pardon. 1.5 trillion, that is what we lost. Can it ever be said that it is not massively urgent to do whatever we possibly can to try and change things? And all we are asking today is an opportunity to argue to your lordships that in terms of Section 19(3)(b) of the Constitution, people that come with a message and with a mission and with a Christian dedication and whatever other dedication they have, to stand in Parliament and to start to change things immediately, that they be given a chance to do so. My lords, it is written everywhere in these papers that there is no accountability. That allegation has not been denied by anybody. The current political system affords no accountability. Will getting a number of independent candidates change that? Of course it will, because then there will be a face to politicians, and they will be accountable. And not only will they be accountable, but the other members of Parliament that know that next election they might be out of a seat that pays them a lot of money will start to be more accountable too. And justices, we can start to turn our country around and make it the country that the Lord wants. So, with respect,
Nelson,
she says,
I'm reluctant to interrupt, and I know that you made a considered decision to dedicate your 10 minutes, your protected 10 minutes to what you have said, and the court has respected that. You are now open to questions and to direction from my colleagues, including the order direction made at the outset of the hearing that we will deal with urgency first.
Justices, I thank you for the opportunity. So, yes. As far as urgency is concerned, justices, we would say that the issue of direct access and urgency should really be heard hand in hand. And these are issues that we have referred to in our heads of argument, starting from page 18, under the heading direct access, and then proceeding to page 21, also dealing with direct access.
Do you accept that it will not be possible, even if you are successful for Parliament to pass the legislation that you say that you want within 6 days? Justice
Frenneman, in answering that question, I need to start to talk about remedies, possible remedies. Because I would submit to your lordship.
Let's start there then. What are you asking for?
There are, if we can turn to section 172 of the Constitution, it says, justices, that you can suspend an order on grounds that are just and equitable. And we would submit, justices, that what you need to do now is you need to weigh up the different options and decide which is the most just and equitable in the circumstances. And we will show you, Justices, that there are a number of options.
I'm sorry to interrupt you, Mr. Nelson. I'm asking a simple question.
Yes.
What order, what remedy are you asking, your clients asking us to make today?
Justices, as you know, in terms of the papers, they have, I think, until the last moment, had the hope that the IEC and the Minister would sit down with them and that they would be able to find a solution in time for independence to stand for the coming elections. That would not appear to be so. We do not, Justices, either challenge that if there has to be a comprehensive new electoral system based on constituencies of the kind that was envisaged by Van Zyl-Slabbert, we do not challenge that it will not be possible to do that within a period of 36 months. But, Justices, as we have said all along, that's not the only remedy. That's a complex system that will take a lot of time. We say, Justices, that you could...
I really don't want to interrupt you unnecessarily, but I'm asking the question again. What are you seeking the court to make an order today?
Justice, if I can take you to section 172, then with your permission. We would ask the court a system of proportional representation being there generally. So we would ask you firstly to make that declaratory order. Then, Justices, we acknowledge for the more comprehensive system there must be a postponement. My learned colleagues for the Minister says 24 months. The Speaker has said 36 months. So we have no difficulty, Justices, in your postponing or granting Parliament an opportunity of 36 months to implement this comprehensive system. But, Justices, that doesn't mean that that's the beginning and the end of your remedy. In terms of section 172 of the Constitution, you may make an order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity. That's fine. We'll take care of all the concerns that have been raised, or you will do in that way. And then, my Lord, an order suspending the declaration of invalidity for any period, and I want to emphasize the next words, and on any conditions, to allow the competent authority to correct the defect. On any conditions. In order to do what, Justices? In order to achieve an outcome that is just and equitable.
Mr. Nelson.
And, Justices, we would say that that includes the need for the election to be postponed. Because in the interim period, within the next 36 months, there is no reason why the constitutional right in terms of section 19(3)(b) cannot be exercised by independent candidates. It's for Parliament to decide how to do that. We have been trying, Justices, for months, for more than a year and a half, to try to get the powers that be and that can help in formulating a procedure to sit down with us and to see what the options are. There are options on the table. They might not be the only ones. There might be others, Justices. There might be others. There are two potential solutions on the table at the moment. The one is that Parliament consider what they talk about as the Lakota Bill. The Lakota Bill was raised by the Speaker. She said she'd come back to the court to tell the court how far the Lakota Bill is. We don't know. But we do know one thing. It can be dealt with within 3 months. It or whatever amendments must be made to it so that a place can be made for independent candidates.
Mr. Nelson, sorry, Mr. Nelson. Just practically today, what is it that you want, what order that you want this court to make? To postpone the elections, is that it?
Justices, there are two options as far as that is concerned. The one is, it certainly would fall within your power to do that, and we believe that would be an appropriate remedy that falls under the provisions of Section 172B2. It's definitely appropriate.
Sorry to interrupt you. I see that your other suggestion was a new ballot paper.
Correct.
Do you accept that that's practically impossible at this late stage?
Justices, it's difficult to say. I think one has to interrogate what the IEC has said in that regard. And what they've said is the following. They say, we don't know how to take care of double voting. Well, with respect, Justices, you don't need to be a rocket scientist to find a solution to that. You put somebody at the front door and he hands out either an independent candidate list or he hands out a party political list. They say they can't train their staff. They've got lots of staff, 200, but with electronic media, it's so easy to train people. I really, with respect, cannot believe that that cannot be done. They say that this might create all sorts of practical difficulties in terms of legislation, but they don't tell you what it is. The legislation that has been referred to deals with things like remuneration and how long you can speak and so on. Those things can be taken care of later.
So can I just get clarity? Which is the exact remedy that you're asking for? Postponement or this new ballot?
Justices, first choice, new ballot in time for the next election. But we accept there could be practical problems with that. But if that can't be done, then allow an opportunity, postpone the election and allow an opportunity for that, all the problems with that ballot system to be overcome. All the problems. There's no intimation that it will take 36 months to overcome those problems. There's no intimation that it will take 36 months to overcome any problems associated with the equitable. The only argument where there's a 36-month delay is where they want a constituency-based system where you've got to go and demarcate areas again. So,
my colleague, Justice Turon, has been wanting to ask you something.
I apologize, Justice, I really do.
Not your fault, Mr. Nelson. I want to follow up on what both my colleagues have asked you. Can you please, with reference to your papers, refer us to the relief that the applicants are seeking in this matter? Because I just have a few questions about that, please.
The relief that is sought, Justices, is firstly declaring that Section 57A and Schedule 1A to the Electoral Act are unconstitutional and invalid.
Please can you refer us to the papers, Mr. Nelson?
I beg your pardon?
Please can you refer us to the papers?
I so beg your pardon. Page 2 of Volume 1.
Talking about the volumes in the Cape High Court, Mr. Nelson.
Justice, yes, I hope that coincides with that.
The notice of motion in this court asks for an urgent hearing and granting leave to appeal, plus further alternative relief. And that's at page 2 of our papers. I don't believe that you filed the Cape Court record here.
Sorry, Justice.
Mr. Nelson, may I intersperse? Mr. Nelson, please. And I know other colleagues also want to follow up on their questions. The practical question that Justice Turon has asked you about what relief you seek and where it is to be found in the papers, following on the questions of the other colleagues, brings us back to the question of why are we here this morning instead of on any other morning at the court's next term sitting, which will be in August. That's the first question. And had we been sitting in August, we'd have had the record from the Cape Court. The court would have had the opportunity, as it always has, to consider whether to invite parties to intervene or whether to issue an order joining parties subject to anything they might say against joining them. It appears that the political parties that up to now thought that the proceedings were of insufficient importance for them to join. They may take a different attitude once they know that the matter will be set down for a hearing in due course in this court. But all of that simply focuses on the question of why we're here now rather than in 3 or 4 months' time.
Certainly, Justices. The relief that is sought is that, obviously, that these declarations of invalidity be made now, and that Parliament be directed to forthwith take all necessary steps to remedy the invalidity and ensure that the second applicant and all other adult citizens that so desire are able to stand for election, otherwise
Sorry, Mr. Nelson.
As soon as possible.
Where are you reading from?
Page 2.
This is of the application papers in this court, because I have the notice of motion and the founding affidavit in this court as to what relief is being sought. Paragraph 1 says, condoning the applicant's failure to comply with the rules of this court. Paragraph 2 says, granting the applicant leave to appeal to this court. Paragraph 3 says, granting the applicants further and alternative relief. Now we're talking about the application in this court. What relief have the applicants asked this court to give? And that is what I see on page 2 of your notice of motion.
Justices, it's obviously to overturn the decision of the court or quo, in terms of which it dismissed the application, asking for the relief that is set out in the notice of motion.
And my further confusion is fueled by the amendment of the relief that was sought. In the High Court, the relief was before the next elections. That relief was amended to read as soon as possible, which is something different. And I think we, and I speak for myself, not necessarily for the other judges, we need clarity on exactly what order the applicants are seeking in this court.
Justices, it's for the reinstatement. In the court or quo, the relief sought as it was before the judge was that the second appellant be placed in a position ensuring that the second appellant and all other adult South African citizens that so desire are able to stand for elections, otherwise than through party lists, to the National Assembly as soon as possible. As soon as possible.
That is very different from in the next elections.
Justices, as soon as possible is as soon as possible. If the elections have to be postponed in order for that to happen, and the elections occur on another date other than in May, then that is as soon as possible. It's nothing other than that. That was the relief that was sought, on the very basis that Chantal Revel put up, that this problem must be resolved as soon as possible. Justices, one of the very powerful arguments I submit why you should hear this matter on its merits today is because if you don't, we will have an election that will not be constitutionally compliant.
According to the applicants, yes.
I beg your pardon?
According to the applicants.
That is true. Yes, that is true.
Now,
that is true. If we're
Mr.
wrong on that,
Nelson,
Justices, then we're wrong on that. We made that point in our application for urgent leave to be before you.
63.
If this is not going to give rise to a constitutional crisis, then much of what we have said does fall away. I must concede that. Mr. Oscar Sawali, for example, says, if you set aside elections after they have taken place, he says the experience in Africa is that will lead to conflict and to violence. And he, Justices, is an expert. And that evidence, too, is not contested. It is not challenged. In fact, the Minister of Home Affairs says he agrees with what Mr. Oscar Sawali says. So what relief do we seek? Justices, you can postpone the issue of a comprehensive amendment to the Electoral Act for as long as is necessary. But it doesn't mean that expression cannot be given to the constitutional rights that people have. These are two different things. The Electoral Act might be problematic. Just like in my vote counts, Apaya was problematic. Doesn't take away the constitutional rights that people have. And I think with respect, it deserves careful reflection on what the constitutional rights are that we are speaking about. We list those, Justices, in our...
Mr. Nelson?
Sorry.
Please, can I remind you that at this stage we're only dealing with the question of urgency and not with the merits of the matter and the rights involved.
I understand. But Justice Tron, are the rights that are going to have to be delayed for 5 years? If you do not hear this matter as a matter of urgency, at least hear, at least listen. You're going to prevent a case even being brought before you as to whether or not those rights are to be exercised for the next 5 years. We submit urgency is very much tied up in what rights are going to be delayed for 5 years. And the constitutional rights, justices that we are talking about, is the very essence of governance in our country. It is the essence of the right of people to vote. Justice Fruneman said in My Vote Counts, it's not just about the individual right to vote, it's about the entire citizenry that gets affected by what happens. And the whole of South Africa, with respect, if these constitutional rights are not exercised over the next 5 years, are going to be massively and harmfully affected. That will be the consequence, and it does tie in with urgency, justices. It really does.
Mr. Nelson, I'm interested to know how, in practical terms, the IEC gets the independent candidates onto the voters' roll. How exactly? I know that you talk about some schedule or them just being stuck onto the ballot paper. How exactly, in practical terms, does that happen?
Justices, can I postulate a solution to you today? Because that's what mediators do. That's what peacemakers do. A solution could be, and I haven't finished what I was saying in that regard, a solution could be give Parliament 36 months to amend the Electoral Act.
I mean, for these elections, because
No, Justice, I'd like to finish.
Oh, thank you. I'm sorry.
Postpone the elections, direct Parliament to facilitate a mechanism that will allow people to exercise their constitutional rights, that will give recognition to their constitutional rights on an interim basis until the big grand scheme can be considered and thought through and demarcations can take place, etc., etc. There is no reason why an interim solution cannot be found that acknowledges the constitutional rights, the massively important constitutional rights. And I'm not talking merits now, Justice, because if we look at the nature of the rights that we are talking about, we are with respect talking about the right to freedom of association, the right to vote, the right to make political choices, the right to campaign for a cause, the right to stand for political office, and if elected, the right to be a member of the National Assembly.
May I ask a related question? In the matter of Mhlophe, we highlighted the fact that according to the Constitution, elections have to take place within a certain time, that is, not beyond a certain time. And I think we even made the point in that case that if the elections were to be postponed, that would create a constitutional crisis. I think that's the term we used. How do you address that constitutional issue, the possibility of a quote-unquote constitutional crisis if the election were not to take place within the time stipulated by the Constitution? Just give us a constitutional argument around that.
Justices, I must concede immediately that a postponement of the election will be disruptive. Cannot challenge that. That's a fact. But with respect, when you decide what is just and equitable, you have to weigh up that prejudice to the prejudice that will be suffered to the whole nation and to individual people, and you have to weigh those two up and decide which is more just and equitable. That Parliament, members of Parliament or governments are inconvenienced because an election is postponed, or the effect on our nation, the effect on our entire nation.
I understand that. I think my question is, prior to us getting to all of that, how in constitutional terms do we get to the point that we are in law or constitutionally entitled to postpone? That's the constitutional argument I'm asking for.
Justices, we have reflected on that. And as there is an application to the Electoral Court that has already been formulated, drafted. It is ready to be delivered to the Electoral Court today. Because the procedure for postponing the elections, if you don't feel that you have the power to do that, with respect, we submit that you most definitely do. But if you come to the conclusion you don't have the power to do that, then the procedure is that the Commissioner If he feels that the elections are not going to be free and fair, which of course is another critically important issue if we have an election without independent standing, then he must request the President, in terms of Section 21 of the Electoral Act, to postpone the elections. We have already asked the Commissioner to take a decision. He took one before the judgment was handed down in the Desai matter. We asked him for another one after we had dealt with the Desai judgment and shown why that judgment was not sound. And he has not yet responded. But there is an application ready to be served this morning, calling upon the Electoral Court to review the Commissioner's decision. And so that the Commissioner then recommends to the President, and if that's where you want to leave it, Justices, then that's also fine. Then let the President take this decision.
Lastly, and please do not misunderstand me, I was not at all suggesting that we do not have the power. I just wanted you to assist us on the basis of the existence of that power if it does exist. So I'm not saying we do not have it, not at all.
Justice, I would suggest with respect that you do have the power, and I would suggest with great respect that the exercise of that power must depend upon what the Constitution says, and the Constitution does two things that I think are really significant. One is it tells you what the remedy is that you can, and as I say, you must choose the one that is the most just and equitable, and it is with respect, it is so that people will be harmed or whatever the case may be, but the prejudice to our country so far outweighs that, Justices, so far outweighs that it is in your power to impose conditions, and we would submit that you do. And even if the condition is, you can see that the appellants have for the last year and a half been begging the Commissioner, the Minister, the President to sit down and to talk about a solution to what is a constitutional crisis.
Mr. Nelson, could I beg you to refer us to the provisions that relate constitutionally or in legislation by which times elections, national and provincial elections, must be held? And if they are not held, under what constitutional provision we are allowed to amend that or let the elections go ahead? I'm asking you to restrict yourself to the legal and constitutional issues.
I'll do that, Justice. Thank you, Justice Froman. I refer again to Section 172B, 172(1)(b), which says that you may make an order that is just and equitable, and an order limiting the retrospective effect, so that's not a problem, an order suspending the declaration of invalidity for any period and on any conditions.
Mr. Nelson.
So, and then I'd also like to refer you to Section 7.2 of the Constitution, if I may. I'm sorry,
Mr. Nelson,
Justice Trump.
if I can perhaps assist Justice Mdlanga and Justice Froneman, if I understand their questions, I'd like you to explore the consequences that would flow for the country if there are no elections. Justice Froneman in particular wants you to refer to those provisions of the Act which stipulates within what period an election must be held.
Thank you. Thank you.
And perhaps if I can just add my own tag along that. If the, as I understand it, and I may be wrong, if the elections are not held within that period, we might not have any parliamentarians anymore because their term of office would come to an end. To bring into force the regime that the applicants seek would require legislative amendments. If we don't have a parliament, who would then bring those amendments into force? I think those are the questions which the bench would like you to explore.
Certainly.
To add to that, Mr. Nelson, my understanding that the cut-off date, if any postponement were to be held, elections for this year must be held by no later than August this year. Now, any amendments that are being brought by this application, we have heard that one is talking of 36 months. How is that going to be possible if we have to have elections by no later than August of this year? And further to that, we know for a fact that the voters outside the country have already cast their ballot on Saturday, the 27th of April.
Thank you.
What is the status of that? Elections basically have already begun.
Justice, I'd like to deal with your questions in the order that you put them to me. Firstly, you are quite right that the maximum postponement that the elections can be is 3 months. So the best that we can have is an election until the 8th of August. We are saying that 3-month period is more than enough time for the separate ballot system that we proposed, that hasn't been dealt with fully by any of the respondents. They don't say you can't do that in 3 months. You can't take care of those
Can you
problems.
get to the separate ballots without an amendment by Parliament? Can you do that?
Justice, if you need that kind of an amendment, legislation can be amended in a relatively short period of time. There is legislation pending before Parliament at the moment, the Lakota bill. It can be amended. If it needs to be amended, it doesn't take care of any issues, it can be amended. It can deal with all of these things that need to be dealt with. There's no indication anywhere on the papers that those matters can't be resolved in the next 3 months. No indication with respect. The Speaker said she'd get back to you. She hasn't got back to you. She hasn't said it can't be done. She's made no further comment on the Lakota bill because it's possible, and that Lakota bill can be amended, as I've said, to take care of the naturalia. But justices, we are arguing now for an opportunity just to be heard. That is all we are asking for. I honestly believe that there is a good prospect that if you hear us on the merits, you will hear that there are good prospects of success on the merits. You will hear that there is no choice but to make a finding that the Electoral Act is in breach of the Constitution. You will have no choice but to make a finding that because of that, there are a number of rights enshrined in the Constitution, some in the Bill of Rights, some outside the Bill of Rights, that will be flagrantly disregarded if something is not done about that. And justices, all we ask for now is an opportunity to address you on these things, because the matter, we say, is of sufficient importance to the country. We are going to have an election that, if we are right on the merits, will not be free and fair. Can it ever, with respect, be contended that this matter is not sufficiently urgent that you shouldn't even hear argument on whether or not the elections, if they take place, are going to be sufficiently fair or not? And as I've said...
Mr. Nelson, I'm sorry.
Justice Chapter.
Do I understand your argument to be that you accept the fact that for your clients to participate in the elections, there must be legislation regulating that?
Justice, not necessarily. Not necessarily. Again, let's just accept one thing for sure, and that is it is not for this court to prescribe to Parliament what it should or shouldn't do in order to overcome this problem. There's a problem, it must be overcome. My client's contention from the beginning has been that with a proper will, the problems can be overcome so that people can stand, not before 8th May necessarily, but in the next elections and as soon as possible. That's always been their contention. You can't, justices, Mr. Sawali, who's an expert not only in peacemaking and mediation, says in his affidavit, he believes that
Mr.
the problems
Nelson,
can be
may I interrupt you? I really ask you in the interests of a reasoned debate. My colleague Jafta asked you a very specific question. Do you accept that legislation will have to be amended? Now, I didn't hear you answering that question. Could you give us an answer to that question,
I answered it, Justice, and I'll answer it again in the same way. Not necessarily.
Mr. Nelson.
Not necessarily. We don't accept that a solution cannot be found without a need for legislation.
I'm sorry to interrupt. I thought you were here because you're saying that the existing legislation doesn't allow you to participate in the election. Now, my colleague asks you the logical result of that is that the legislation must be passed. So I don't understand. Why are you here because you say the legislation is not good enough and you can't participate, and therefore legislation must be changed? Or what is the position?
Mr. Nelson, if I may just add on to what my brother has just said, I am confused about what order you seek this court to make in this application. I thought I understood your submissions to be that you want to have Section 57A and Schedule 1A of the Electoral Act declared unconstitutional and invalid.
Correct. That is correct, Justice. That is what we want. But what we are saying is, with respect that, is there no other way? Our question is there no other way? And it's a valid question, Justice, but is there no other way in which constitutional rights cannot be protected on an interim basis? Is there really no other way, in a manner that everybody will find acceptable, until such time as the elections, as the amendments can be made? And Justices, let me make this very clear, because it's a mistake that the Judge Okwo made, and I'll take you to the passages if you want me to. It is also a mistake that our learned colleagues make. Our clients have said from the outset that the changes can be made in a number of ways. They've not said that it must necessarily be the complex mechanism envisaged by the Van Zyl-Slubber report. Never. That's not been their case at all. They have said that there must be another way also to allow independent candidates, like the second applicant, to exercise their rights immediately. Would you like me to take you to those passages? Because that is important, Justices. There are different ways of solving this problem. And our clients have tried everything in their power to find a way.
Mr. Nelson, I'm sorry. I don't follow that argument. I thought your clients accept that elections in the country are regulated by the Electoral Act.
Correct.
And therefore, they brought their claim within the ambit of that act, attacking the act. They did not rely directly on the Constitution to say, we want to exercise our constitutional rights irrespective of the fact that there is legislation that was passed to regulate the exercise of such rights, because that legislation is deficient. Their claim is that the legislation that is in place is deficient, and therefore it is unconstitutional, which seems to suggest that they were alive to the principle of constitutional subsidiarity. They wouldn't just come directly relying on the Constitution. So if you accept that proposition, the next question is, what would be your submission if the Speaker convinces us and the other parties convince us that within the period of 3 months that you have agreed that the elections would have to be held, the necessary amendments cannot be effected? What then?
Justice Jafta, this is an unfortunate situation in which I find myself, because I happen to know that there was an application by Mr. Michael Louis to be an amici in these proceedings, supported by affidavits, and in which he explained in elaborate detail what has been done in order to bring about legislative change, simple legislative change. I'm not talking, and this is where we want to distinguish things, we're not talking about the complex constituency-based system of Van Zyl-Slubber. We acknowledge that will take 36 months. But a simple amendment to the Electoral Act to allow independents to stand now, such legislation is before Parliament, and according to the evidence of Mr. Michael Louis and Mr. Lecorta, who are present in court, you can ask them, that legislation is ready to be dealt with now. In the previous papers that were filed, the Speaker said she would get back to you and tell you what's going on with that legislation. That's what she said under oath. She knew about it. She confirms it. But she doesn't get back to you. She says nothing. What must we all infer from that? That obviously it's possible for that legislation to be passed.
So do I understand from that that you now accept the question posed to you by my brother Jafta is that legislation would have to be passed?
Justice, you know, unfortunately, I'm a mediator, and that's a very difficult concession to me.
No, but you're
to
not a
make, because
mediator
there
in
are
court.
always options.
I'm sorry to interrupt. You're not a mediator in court. You're an officer of this court. You're here to make legal and constitutional submissions to help us.
I raise my hands. Lordship, Justice, you're quite right. Let us accept for the argument then that you would need legislative intervention. The nature of the legislative intervention could differ depending on how much time, but within the 3 months it's possible to have legislative intervention, yes.
Mr. Nelson, accepting what you have just said in response to Justice Froneman, pursuant to the question asked by you by my brother Jafta, I just want to find out if it would be feasible and practical to amend the Electoral Act and other related legislation before August of 2019.
Justice Kempepe, there is currently a draft bill, and there is evidence under oath that it can be done before the 18th of March. Evidence under oath.
Mr. Nelson, Parliament has dissolved right now. We are waiting for elections to be conducted. Then we'll have a new Parliament. So if we postpone for 3 months, what's going to happen? We don't have a Parliament. It has dissolved.
Justice,
So who's going to amend this legislation?
in terms of Section 84 of the Constitution, the President has the power to call a meeting of Parliament at any stage to conduct special business. This would be special business.
A business of amending.
Yes. Again, Justice, is the nature of the participation depends upon the nature of the change that is sought.
I'm sorry, Mr. Nelson, I'm sorry, I don't follow that. I thought Section 84 applies in cases where there is Parliament in existence. It is merely the calling of the meeting of Parliament. The President cannot reconstitute Parliament once it has been dissolved. That's the point that my sister is raising with you.
Justice, Section 84 doesn't say that, and I can take the argument no further. It doesn't say that.
Mr. Nelson, can I just ask one question? You've gone to great lengths to say that the elections won't be free and fair. Does that mean, are you saying that proportional representation, elections, the proportional representation system, which we presently have, is not free and fair?
No, Justice, that's not what I'm saying. With respect, our contention is that if, as this court held in the My Vote Counts matter, Section 19.3b means that any South African citizen can stand for election to the National Assembly and the provincial legislatures, and if elected, can be a member of that parliament. If that's what the Constitution says, it doesn't postpone that right. The right is and it exists. People can vote for independent candidates in terms of the Constitution right now. So, if we have a system that doesn't facilitate that, those elections can never be free and fair, Justices. It can never be free and fair when our Constitution says that government must be based on the will of the people. And our government currently is not based on the will of the people, but on the will of party political bosses. That's not free and fair.
But I go back to my question. At the moment, it's based on a party system, proportional representation. Are you saying that is not, the upcoming elections will not be free and fair because they're based on a proportional representation system where one votes for a party?
Absolutely, Justices. They will not be free and fair because they will not give recognition to constitutional rights for independent candidates to stand, and for people to vote for independent candidates, and for people to determine what our parliament looks like, and for people to determine who our president will be.
So all past elections have not been free and fair in your view?
Absolutely. Absolutely, Justices. It all depends on how you interpret Section 19.3b. The consequence might be horrific. This court deals with horrific consequence matters every day. But we don't have to worry about past elections. They've happened and they've done, and we've seen what they've done to our country, Justice Heath Nichols. We've seen what they've done.
I'm going to ask you to wrap up your submissions on urgency. We've heard you for almost an hour. Can you compact your submissions and bring them to a close. Thank you.
So, Justices, we do say that you should at least hear us in this matter and not dismiss our right to make representations to you without listening to us, simply on the basis that the matter is not urgent. I wish to stress, Justices, and I think this is really important, that this urgency has not been caused by the appellants at all. On the contrary, the appellants have done everything in their power, everything, to make sure that you are not confronted with this situation. 2 of the recent postponements, 6 weeks we lost because of what happened at the lower court. I don't want to go into the detail. You know the detail. A month we lost before that because the Minister of Home Affairs, who at that stage was the only opponent, said he needed a month to deal with certain allegations in the papers. I can take you to those. He needed a month. In the end, in 3 lines, he answered the very allegations that he said he needed a month for, in 3 lines, saying it's matter for argument. Our clients are not responsible, Justices, for placing you in this invidious position, and they are sorry that it has happened this way. But they truly believe. Give them a chance, at least to put their case before you. Hear them in this matter as a matter of urgency. The issues here are massive, massively important for our nation and for our people.
Mr. Nelson, I just would like to take you back to some of the debate that you had with my brother Justice Jafta, and perhaps also just to mark a little bit of my personal unease about the manner in which this matter has evolved. Can I refer you to the heads of argument filed by the Minister of Home Affairs, please? Paragraph 1. It says, in the proceedings in the court are quo, it was not disputed that amendments to legislation arising from any finding of constitutional invalidity as proffered in the application would require a period of at least 2 years. Here, it seems that this was not disputed in the High Court.
I'm sorry,
and let me just finish, please, Mr. Nelson. Even in the heads of argument or in the submissions that were made by the applicant or the papers, that's not taken any further. And we spent about 10 to 15 minutes today to try and ascertain the position of the applicant and whether the applicant realized that or accepted that there would have to be legislative amendments in order to secure the electoral regime that the applicant seeks.
Justices, I can only say this once more, and that there are different legislative mechanisms that can be employed to address this problem. It has always been, there's been no concession and no change in attitude whatsoever at any stage by the appellants, that there is one mechanism, and that's the constituency-based system where you've got to go and demarcate areas, and that's going to take 36 months. We don't dispute that. We never have. But we have contended all along, Justice, and I'll take you to the paragraphs, because this is the problem. This submission is not correct. We have contended all along that with a proper will, there could be simpler solutions to the problem. There could be simpler solutions to the problem. We point out that we are not electoral experts. Michael Louis is. He wanted to put evidence before you. You've not allowed him to do that. That says there's a simple way to solve it. Through legislation. It can be done within the 3-month period. Confirming exactly the point that we've been making all along, Justices. So this submission is not correct. It's not factually correct. And I'll take you to the references in the papers, and perhaps I should do that with your permission, just very briefly, and Justice Cameron, if you would allow me to do that.
I think we have your submission, that there are simpler solutions that can be done within 3 months legislatively. Whether that stands in the light of the questions put to you about the dissolution of Parliament is a matter that this court will determine in due course. But unless you have further submissions on this aspect, Mr. Nelson, I'm going to ask the Minister, Counsel for the Minister, to make submissions.
Certainly. Justices, I don't want to repeat what I've already said, but of course one of the major concerns is that if the elections take place, and the point in terms of the My Vote Counts is correct, we might well be faced with an election that takes place contrary to the Constitution And the evidence before you of Mr. Oscar Sawali is that that could lead to violence. Thank you, Justices, for your patience.
Thank you, Mr. Nelson. Mr. Kassam?
Yes, I don't intend to detain the court for more than 10 minutes on urgency. The test is articulated by Mr. Justice Froneman in the Ramakatsa versus Mahashulu matter at paragraph 40. It's the only paragraph I'm going to read. This court is not well geared to hear urgent matters. Urgency may afford grounds for engaging this court directly, but in order for it to do so, an applicant must establish that a delay in securing a definitive ruling would, and this is the operative part, would prejudice the public interest or the ends of justice and good government. And then in paragraph 42, His Lordship, by reference to the Union of Refugee Women case, sets out the 4 criteria which the court will have to be satisfied before you give direct access. I'm not going to labor the point. On prejudice, there are at least 6 grounds I submit favors public interest for the election to proceed and not to give effect to what has been argued in favor of urgency. And these 4 are the following. These 6 are the following. The first is my learned friend, Mr. Budlander, in paragraph 57.4 of his heads of argument at page 23 to 24, quotes an extract from the replying affidavit in the High Court proceedings. Again, I have to just read this paragraph. The first applicant does, however, accept that a more elaborate system of independent candidates of the kind envisaged in the late Van Zyl Slubbert report will, for the reasons explained by the 3rd and 4th respondents, not be ready in time. The first applicant has, for that reason, established a special purpose vehicle called the House of Independence, and which it hopes will afford a larger number of people who share its vision in relation to the electoral process access to Parliament at this stage already. The House of Independence have accordingly been registered as a political party under process. It hopes to be a haven for those people who would otherwise have stood as independent candidates had the Electoral Act been constitutionally compliant. So it's not that they say they don't have relief. They say we want the luxury of a different form of system. The second point is we point out that voting took place in 121 foreign missions on Saturday, 27th April. Again, I'm referring to my learned friend, Mr. Budlander's heads. 63.6 million ballots at a cost in excess of 38 million has been produced to accommodate 48 political parties. You need a special 600 millimeter voting sheet because of the number of people involved. The third point I want to make is the preamble to the Constitution, and Section 1 of our Constitution provides inter alia as follows. The point I have in mind is the preamble says it's an open and democratic society where the will of the government is determined by the people, and that's your general elections. And then the Constitution itself in Section 1 the Republic of South Africa is one sovereign democratic state founded on the following values. 1D, universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. That's given effect to by an election every 5 years, as set out in Section 49 of our Constitution. Any delay naturally causes chaos, but provision is made for a 90-day period, which is not seriously addressed by my learned friend. Then finally, I must make, one further point before my final point. My learned friend bases his entire address to say it's not constitution compliant and there's a risk that these elections can subsequently be attacked and set aside. I would with great respect submit that there's no merit in that submission for the following reason. The system that's presently in operation is constitutionally compliant until it is set aside. An authority for that would be paragraph 14 in the New Nations case, if I may just be permitted to refer to the judgment. That dealt with the bar-coded case. In paragraph 14, this court said the following. The right to vote contemplated by Section 19.3 is therefore a right to vote in free and fair elections in terms of an electoral system prescribed by national legislation which complies with the aforementioned requirements laid down by the Constitution. The details of the system are left to Parliament. The national legislation which prescribes the electoral system is the Electoral Act. It repeats the requirements for voting as being South African citizen, a minimum age of 18 years, and enrollment on the National Common Voters Roll. These are the requirements set by the Constitution for the exercise of the franchise. The submission is that until a court says that's set aside, you have a constituently compliant system.
Do you accept, though, that if we do not hear the matter today and postpone it and make no decision on the merits of the application, then it's open for the applicants or anybody else to contest the validity of the elections that take place next week, and the effect of that, if successful, might even be to invalidate previous elections. So in that sense, there's the possible prejudice to the applicants can be cured.
Yes. Yeah, that's the answer. It can be cured in the other way. On the other side of the spectrum, if you stop it now, it's not fair to the people who have the right, and it's a hard-fought right, as this court has said.
I just want to know that you accept that.
I accept that. I accept that. So the prejudice on the balance is in favor of allowing the election to proceed because they have a remedy. Finally, I do not quarrel with the...
Mr. Kasim, can I take you back to the first point that you made about a political party having been registered to advance the interests of the applicants? Is that still feasible? Can they be accommodated under that political party before the elections next week on Wednesday?
Judge Jefta, I would submit the issue is this. If they didn't get their act together, they can't comply now because they chose not to do it through a political party. Then they say, well, we are going to register a political party to exercise this right under protest. For any practical reason, if that wasn't done, then I simply submit that it's not a factor this court should take into account.
But my query relates to the proposition that they have a remedy. That is what you submitted.
Yes.
But I'm asking whether that remedy is it still available to them for you to argue today to us that they have a remedy?
Well, I would submit on the basis, I'm informed that Mr. Budlander is specifically going to deal with this aspect, but I don't want to avoid the issue. I just don't want to waste time, but I would submit the following. The manner in which Section 19.3 has been implemented and in judgments interpreted is such that you exercise your political right via a political party. So that was always available to any individual. And that really is going to the merits of the matter. But I'm simply submitting that on an urgent application, the usual test will be, do you have an adequate remedy? And I would have argued on the facts before this court, they do have an adequate remedy because they're saying, I elect not to use that remedy. On an urgent ground, I would say, yes, it is. It doesn't mean that in the fullness of time, they cannot contend that to give proper effect to their right, it means that they can stand as an independent candidate. There's one further aspect I just want to make clear. My learned friend spent at least 8.5 minutes telling this court that this is a good lady and we accept it, and she wants to cure all the ills of the world. There's no causality between what is said to you and why, if she becomes a member of parliament, as an independent, she could then succeed in overcoming all those deficiencies. In fact, I want to go further. The good book on which she relies, the scriptures, talks about public good. If she is that kind, compassionate, and considered person, she wouldn't want to upset an election 6 days away with the majority of the people, and this is not on the record, but I understand over 26 million registered voters want to exercise that right. It's a hard-fought right. So I would submit that there's no grounds for urgency. And for that reason, the application should be struck off the roll as we submitted in our heads of argument. The issue itself is a real issue. It must be debated in the fullness of time. As the court, please.
Could I ask you a last question? You're asking for the matter to be struck off the roll. What is your attitude towards, if we come to that conclusion, and I want to emphasize that I'm just asking in my personal, if the matter is postponed for a hearing in August, would you have any objection to that?
No, Justice Foreman, no. On the case we've put forward, if they are right, then at least you need 3 to 4 years to get your electoral processes in order for the next election. So one would...
You gave me a very good short answer. You don't have to elaborate.
Thank you, Justice.
Mr. Kasim, another good short answer, please. The political parties had 2 opportunities, in January when the applicants wrote to them, and then in April when Mr. Justice Desai postponed for 2 weeks so that the parties, none of them came in. They might come in now. Should this court consider, were there to be a postponement to August, to direct the parties to indicate why they should not be joined, or should the court simply leave it up to the parties? Does the executive whom you represent consider that the matter can be adequately debated before this court with the Commission and with the applicants and the executive before it?
Short answer is, Justice Cameron, with having regard to the enormity and importance of the matter, I would with respect submit that the court should direct that all interested parties be joined. Once again. I know Justice Desai did that. Nobody came to the party, but the gravitas of this court and the importance of the matter, I would submit requires greater participation.
Kasim, what are your views on whether this matter should first go to the SCA?
We've said in our heads of argument, we think it should be articulated in the SCA simply because there are conflicting views emanating from this court, be they arbiter. So we've submitted it should go to the SCA, but I understand the time frames. It doesn't mean that a priority hearing cannot be had in the SCA, but I would not have objections if the matter was re-enrolled here in August. As the court pleases.
Many thanks, Mr. Kasim. Mr. Butler.
Helen, can you take that? Thank you.
Butler, just to confirm that you voluntarily, of your own accord, sua sponte, waived your time this morning in chambers. It was not put to you by the presiding judge that you will waive your 10 minutes.
Mr. Cameron, I respond as I did in chambers, which is I waive my time for this hearing only and reserve my rights for the balance of my career. Justice Cameron, I will too be brief. The court has debated the issues at length, and we wish to make the following points. 3 of them. Firstly, we wish to just draw the court's attention to the effect of section 49(4) of the Constitution. I'll come to it in a moment. Secondly, we wish to make reference to the decision of this court in a party, which appears to us to provide the appropriate response. And thirdly, we wish to just add a gloss on some of the reasons that have been added why it is not in the interests of justice or for this court to deal with this matter on an urgent basis. Justices, firstly, section 49(4), we simply draw the court's attention to it because we would not wish the court to misunderstand the position with respect. Questions have been put to our learned friend Mr. Nelson about whether Parliament remains competent to function given that it has dissolved. It seems to us, although the question is not, it seems to us that as of today, Parliament is certainly competent to perform its functions, because 49.4 provides that the National Assembly remains competent to function from the time it is dissolved or its term expires until the day before the first polling day for the next Assembly. So Parliament is still competent today. A more complicated question with respect is whether Parliament would still be competent for the next 3 months if the first polling day is postponed. I really don't wish to make submissions on that score because it is a complicated and far-reaching question. I simply draw it to the Court's attention for the assistance of the Court. Given that
does the Electoral Act have a definition of the first day of polling? Because it might, since polling has already started, there have been many, many votes, 100,000, hundreds of thousands as I understand. It may be that the first day of polling has already passed.
No, with respect, you may well be right, Justice Cameron. The answer is it doesn't on the face of it. My attorney, who knows this Act better than anybody else, tells me it doesn't, so I trust him, and I don't think it does. But we would simply respectfully submit that there are many reasons to refuse this application on the grounds of the interests of justice without getting into that complicated and potentially far-reaching issue, and we would respectfully ask the Court to do so. The second point, then, is simply to draw the Court's attention to the judgment in A party, which we refer to in our heads of argument, because it seems to us, we endorse what our learned friend Mr. Kassam has said about Ramakatsa, which is very helpful on the question of urgency. We would simply add what is said in A party, and that is to be found in paragraph 14, page 7 of our heads. And there the Court was similarly dealing with an urgent challenge to the electoral scheme on the grounds that it deprived people of the right to vote, effectively. And this Court said unanimously, it is not in the interests of justice to deal with constitutional challenges that involve the fundamental nature of the electoral system provided in the Electoral Act on an urgent basis, particularly where no immediate relief is sought. The applicants have not shown exceptional circumstances justifying this Court in exercising its discretion to grant direct access. That admittedly was a direct access case, not a direct appeal case, but we submit the same applies. This Court, with great respect, should not be forced to deal with these far-reaching issues in a matter, in the urgent manner it has been asked for. Now,
may I interrupt you?
Of course, Justice.
What do you say to the applicant's point that it's not their fault that the matter is now urgent?
Yes.
They wanted it to be adjudicated last year.
Yes.
And for reasons beyond their control, it hasn't happened.
Yes. Justice Froneman, in this Court and in a matter of this kind, it's not a debate with respect about fault. It's a debate about consequences. And even if we are to accept, and there is some force in the applicant's point that they have tried to get it heard quickly, that is not the most important question or even an important question. There are 43 or 45 million South Africans who have an interest in having the elections take place timeously and having it take place efficiently. And there are 45 million South Africans who have an interest in this Court pronouncing on this very far-reaching matter once, properly, and not hurriedly. And those interests must outweigh any question of fault. So we place no reliance on the applicant's fault, save for one point, which I'm going to come to, about the registration of the House of Democrats as a political party. But fault is not the question. Consequences are the question, and the interests of justice are the question. We now come, if we could just add a gloss, we endorse all of our learned friends, Mr. Kassam's point, we would just add a gloss on 3 points as to why it's not in the interests of justice. And the first is that the relief that the applicants now seek from the bar was never sought before the High Court, and it was never sought before this Court in its papers. When the case began, the case sought the declaration that the legislation was invalid, 2 declarations, that's Pres 2 and 3 of the Notice of Motion, and then a declaration that there had to be provision made for independent candidates as soon as possible and in time for the 2019 elections. That was Prayer 4 of the Notice of Motion in the High Court. Nothing about separate ballot papers, nothing about postponement of elections. And so the IEC and the Minister answered the case. And we answered the case, my clients answered the case and said, it is simply not possible to do by the 2019 elections. That answer was in October 2018. In November 2018, the replying affidavit gets filed. The replying affidavit does not gainsay any of that, and in particular does not say you can't do everything, but you can still accommodate independence in 2019 by doing the following. It does not say that. And in fact, that's when the amendment occurs, and the amendment is that Prayer 4 is removed and amended to say you must make provision for independent candidates as soon as possible. Now, the applicants made that election, and they did so presumably on the basis of legal advice, but it was a clear, thought-through strategy. They decided, let's wait for the next election. That's the only inference that can be drawn. The matter then comes to this court on the 18th of April. By then, it's clear what's happened. The High Court has pronounced, yet there is no relief sought postponing the election. There is no relief sought regarding a 90-day postponement and a short fix, and there is no relief sought regarding a separate ballot paper. So when my learned friend says, well, we've never had an answer as to why you can't do it in 90 days on a separate ballot paper, well, that's true. But the reason is because that case has never been put up as the relief sought. Now, with great respect, the applicants are no doubt well-intentioned, but you can't go to the High Court, not ask for the relief, make a replying affidavit and abandon the relief about 2019 elections and an amendment in the notice of motion. Do not ask the High Court for a postponement, come to this court on an urgent basis, and you don't ask for the relief, and then arrive at the hearing and expect that Section 172 will help you. With great respect, there is no basis for those kind of orders to be made. And so the difficult question that Justice Madlanga poses, which I'm not going to answer with respect, about whether this court has the power to postpone beyond the remit of 90 days, it doesn't arise, because the postponement was never sought. Nobody has prepared on that issue. The political parties have an obvious interest in them, and you can bet, Justice Cameron, that they may not have decided to intervene in the main fight, but if the applicants had asked for the postponement of an election by 90 days or beyond, they would have been here. And so with great respect, that is not a course that is open to this court. So having
while you're dealing with that,
Yes.
Does the Commission have any views on whether the court were to postpone the matter sine die or to a date in August,
Yes.
should try to lure or otherwise edge or nudge the political parties represented in Parliament in?
Justice Cameron, we in the High Court, we adopted the stance, the Commission adopted the stance that the political parties should be notified. We persist in that stance. We don't think that this court, with respect, needs to go to the trouble of joining them, but the court should, in its directions, direct that the registrar serve those directions on the political parties, and the political parties can then make their election as to whether to come in as an amicus, as an intervening party, or to sit on the side. But it would be appropriate with respect for them to be told. But the court doesn't need to formally join them. That may make things unduly cumbersome. And it may suggest to the political parties they're under some obligation to come, which of course they're not, but they should at least have the ability to do so. So the first of the 3 points is this relief was never asked for. It's extraordinary relief, and this court, with respect, even if it has the power to grant that relief, should not do so, and it would not be in the interest of justice. The second reason is that the applicants made an election not only to abandon their relief in respect to the 2019 elections, but also to form a political party. And this goes to Justice Jafta's point, which was put to our learned friend, Mr. Cassim. Justice Jafta, we accept that that remedy is no longer open for them. The applicants can no longer register a political party. But when the same deponent who we heard so much about, on oath, says, we have registered a political party to take part in the 2019 elections, and then it emerges in the hearing before Judge Desai from our learned friend from the bar that that never happened, and that's confirmed before this court. Well, with great respect, that is an alternative remedy par excellence. This court knows in an interim interdict context, in an urgency context, the question is there an alternative remedy adequate in the circumstances? Well, the applicant herself, the deponent herself identified that as an adequate remedy, alternative remedy adequate in the circumstances, and it was one that they didn't pursue. Having elected not to pursue that, they cannot now ask this court to decide these far-reaching matters on an urgent basis. So it's no longer a remedy, but it's a remedy they had, and they elected to forego it, and that counts against them. Lastly, with respect to this notion that was bandied about in the High Court, again, and is bandied about here, that this court risks creating a constitutional crisis if it doesn't decide that. With respect, that is simply not so. This court hears cases all the time, that deal with legislation which has been relied on in the past, and that this court has to strike down and deal with the question of remedy. It does it all the time. This court will deal with this matter as it does every other matter, which is that it will first determine whether the Act is unconstitutional in August or whenever it gets there, and if it is unconstitutional, it will grant a just and equitable order in the circumstances, including a debate about retrospectivity. And it will, Justice Froneman, in answer to your question, be open to the applicants to argue that the election should be set aside in that regard. They will have an extraordinarily high bar to overcome, but at least then we will be in a proper forum with proper debates, and this court will decide the matter, as it always does, on the basis of what is just and equitable. So our respectful submission is that this is a case which ought never to have been brought in this forum, in this way, and it is certainly one that should not be entertained in this way, and the appropriate order is either dismissing the application on the grounds that it's not in the interest of justice to hear it, which would allow it to go via the SCA, or striking the matter from the roll, or postponing it to a date in August. We are agnostic on which of those routes should be followed, and we leave that in the hands of the court. We do not seek an order for costs as the Commission, despite the fact that, with respect, the time and expense that has been put to this, what is in truth an unnecessary saga, is extraordinary. But we would simply place on record this. There appears to be a suggestion that there is another application coming, and that there is an application that is going to be launched in the Electoral Court as we all leave here today to try and postpone the elections. We would simply record, so that no one can be any doubt, that the BioWatch principle has its limits, and that the applicants should think carefully before doing so, because it seems to us that that would be an entirely spurious application. And there must come a time when even well-intentioned litigants know that there is a prospect of costs awards if they pursue unmeritorious litigation. The Commission does not seek any order today for costs. We accept that each party should pay its own costs. If I could just check if there's anything else. Justices, Justice Cameron, those are our submissions.
Thank you, Mr. Badender. Mr. Basson, on behalf of the Speaker, I take it that you don't, on your watching brief, you don't have any intervention to make?
Justice Cameron, if I may just make a short intervention. There's been a submission that 3 months is enough time. I just want to draw your attention to paragraph 6 of the Speaker's affidavit before this court. When the proceedings were launched on the 17th of September, the Speaker says, at the time of deposing to my affidavit, I advised the Western Cape High Court that in the light of the legislative process details in the Constitution, it was simply impossible for Parliament to amend the Constitution. And this is taken into consideration that the case of Doctors for Life, which says that it will have a huge impact. So it's simply impossible. There was a reference made to the Speaker and the fact that you would get back to the applicants with regard to a draft bill. In that regard, it's on page 132 of the record. A draft bill was introduced which didn't make the criteria for a draft bill. The Speaker responded to say that if indeed it does make the criteria, she will advise the court. She'd advise the court because then it would raise a separation of powers issue with respect that there'd be a bill before the legislature and would be inappropriate for a court to deal with that. This is not the case currently. Justices, those are my only submissions.
Thank you, Mr. Basson. Mr. Nelson, reply.
Thank you, Justices. Our learned friend, Mr. Wills, will deal with the reply.
Justices, there was adequate opportunity given to Mr. Nelson at the outset to make the points that he did. I wish to make 3 points. The first is that all the arguments from the respondents placed before you this morning can be adequately dealt with by the fact that there is a bill before Parliament. Whether that Parliament can or can't be reconstituted, the fifth Parliament can or can't be reconstituted under the powers of the President, we say it can. And Mr. Nelson said that the Constitution doesn't exclude that power. Be that as it may, that is now in your hands. But it deals with all of the arguments as to remedy, the test to urgency, to direct access, and just to repeat Mr. Nelson's prayer, that the fuller detail on the merits be heard. The second aspect, which I think deserves some comment, it is dealt with in Mr. Nelson's heads, relates to whether or not a political party registered was an option. Mr. Badlender has conceded that at this late stage, the registration of a party is not an alternative remedy available to the applicants now. But that party was registered as, at the time, exploratively, not as a remedy to trump what it's doing now. Otherwise, it would have been pursued. But in any event, that falls within the realm of a political party. And if one has regard to what Mr. Nelson sets out in his heads, allow me to just find it. It is that, sorry, where is it? Mr. Nelson, we'll have a look for that while I continue, but he deals expressly with why it's not possible. It's impractical. You can't have a list of members of a party, and that's what the Electoral Act requires. I think it's 115, I might be wrong. When you want to stand as an independent on your own, you're not interested in competing with other members within a political party, such as we see in the current political system. The nub of what Mr. Nelson has placed before you, in which we urge you, is simply to hear the applicants on the merits, such that it would give you greater insight in debate as to what the possibility is, and that not excluding a bill that is before Parliament that could be passed and that could give effect to the rights, which are these rights, both to vote and be voted for, which are fundamental, and as Mr. Nelson sets out in his heads, affect a myriad of other rights. They implicate a myriad of other rights.
But do you accept that if the matter is postponed and there's no judgment on the merits, the applicants are not deprived of putting their case at a subsequent occasion, and they will still have remedies, or if they're correct, the possible remedies are to declare elections, this one, past ones, unconstitutional and defective. So a postponement does not prejudice the applicants in that sense that they are deprived of an opportunity to present their case to this court or any other court.
Mr. Frenneman, two answers to that question. The first is, as Mr. Nelson attempted to make out, is that the very postponement of the matter to August spells prejudice in principle. The second answer. No,
I'm sorry, just explain that to me, please.
If I have a right,
in terms of legal,
if citizens have a right to have a fundamental right, and it's available to them now, by this court not exploring a remedy now for them to exercise that right, they are automatically prejudiced. With respect, we say.
I'm asking you, what is the legal prejudice? If they are going to be heard, and if the remedies that are available to them today are still available at that stage, what is the legal prejudice?
Well, the legal prejudice is the same as looking back on past elections that in debate may be open to being set aside. It's lost opportunity, it's gone forever. The second answer to your question might assist. There appears, unintentionally, but nonetheless, there's a concession that even by postponing this matter to August, there's a concession in this court and how this court operates that there is urgency. Now, urgency is a matter of degree.
Don't tempt us, Mr. Willis. Tread carefully.
So, Justice Cameron, I think everybody recognizes, the respondents too, in their submissions, that there's need for change and there's need for the proper facilitation, yes, in due course, for the entrenchment of this right. But against the circumstances that prevail, historically how this matter has come before this court, indeed no fault, albeit not a matter of fault, the fact remains that the case placed before this court today is one in relation to fundamental rights. Mr. Nelson has referred you to Section 172. We stand before you verily believing that there could be a solution if one's minds are applied to it. Of course, we recognize that there needs to be more debate. We ask you for that opportunity. That is our reply. Thank you. Yes, sir.
Thank you, Mr. Willis.
It appears that sorry, if you bear with me. the answer to why the House of Independence was never a solution in... Sorry.
Apologies, Mr. Willis. Please
my
proceed.
Apologies. My apologies, Justice Cameron. It's at paragraph 18 of Mr. Nelson's heads that he deals with why a political party... Sorry, he's pointed me to the replying affidavit. It's spelt out in greater terms. Thank you.
The court will adjourn and will indicate to the parties when it will reconvene. So the court takes the adjournment now, but proposes to reconvene within a time at present unspecified. Thank you.
Come,